morning, everybody, and thank you again for being here. As Mike mentioned, I am going to be sharing on estate planning and insurance, and I've actually titled my PowerPoint presentation today, Protecting Your Assets, because of course you can actually, estate planning and insurance are different ways that you can actually protect your assets, and so that's what I'm going to be sharing on today. And first of all, I wanted to take a few minutes to talk about what are assets. Many of you may already know, but assets consist of anything that you own in the form of money and also property that you actually have that actually has value. Those are what assets are, anything that, whatever it is that you own. When you actually own assets, you can do a variety of things with those assets. They can be used and you can distribute those assets to others. For example, you can spend those assets on things that you desire, regardless of what those things are. It's a matter of choice. You can actually save those assets. You can invest them, and then you can also transfer assets to people, so you can distribute those assets. Basically, the total of your assets actually is what make up an estate. For some strange reason, my PowerPoint slide is not advancing. Okay, here we go. It's just advancing a little slow. Okay, what is an estate? An estate basically is the total of all the money and property that you actually own. Some people tend to think that if they're not wealthy, then they don't have an estate. Everybody has an estate, regardless of the value of that estate. We all have an estate. It's just a matter of some have, if some people's estate has a lower value than other people's estate. And you have an estate during life, and then you also continue to have that estate during death until after all of your assets have actually been distributed to other people. So when you're living, you have your estate, and basically you're choosing at that point in time to do what it is you want with those assets in your estate. And then after you die, you have the option of choosing to do what you want with those assets after you die as well through estate planning. Okay, let's talk a little bit about estate planning first. Estate planning is basically has three primary points, as you can see here. Estate planning involves three different things. First of all, it involves accumulating assets. Accumulating assets, you accumulate assets through saving and investing. And basically, if you don't save and invest during your lifetime, your value of your estate is not going to be valued very much as you continue to grow, as you continue to age in life. So some people choose to do a lot of saving and investing, and others choose not to do as much. So how much you accumulate during your lifetime is going to be dependent on how much you choose to save, how much you choose to invest your money into. Also, estate planning involves preserving your assets. Preserving your assets is so important because even if you accumulate assets and you do not preserve those assets, you're at risk of actually losing those assets. So you preserve those assets by managing risk and also, in many cases, purchasing insurance, which I'm sure that you all are familiar with. And then the third thing that people do with their assets, which is a part of estate planning as well, is actually distributing those assets. And as I mentioned earlier, you can choose to distribute assets during life, and also you can choose to distribute assets after death, and you can do a combination of both of those things. Okay, how do we accumulate assets? Many of you may or may not be familiar with the differences, financial assets and then real assets, and what some people just refer to as property. Financial assets are those things such as stocks, bonds, mutual funds, things of that nature. And of course, stocks are basically when you invest in companies. Bonds are basically when you are actually loaning money to a company or governmental agency. And when you have mutual funds, you can have mutual funds that have a combination of different types of investments in them. You can have stocks and bonds, a combination in one mutual fund, because a mutual fund is actually an investment company. So basically, the mutual fund is investing in different types of investments for you. And then you can also accumulate assets through the purchase of real assets. Most people aspire to own their own home. Even though you purchase your home as your residence and your primary residence, it is still considered an investment for you. And then some people may choose to even purchase additional second homes, or even some rental property that they choose to rent out. Also, real assets include things like land that you may own. Some people may purchase timberland. Real assets are considered things like automobiles and personal property, those things that are actually tangible. When you look at the difference between financial assets and real assets, financial assets are not tangible. Basically, you don't put your hands on them, but they actually exist. But your real assets are more tangible types of assets. So that's how we go about accumulating assets to actually start having a valuable estate at some point in our lives. Okay, when we talk about preserving assets, as I mentioned, what you're focusing on primarily is trying to manage risk. And of course, you can manage risk in various ways. For example, you try to avoid different types of risk. Of course, there are certain things you can do to avoid risk, like locking your doors so people can't get into your home or your car easily. You can try to reduce risk, and you can also, if you encounter that particular risk, you can actually try to control the loss. So there's some different ways that you can manage risk, but even in managing risk, it's not always practical, and you cannot always manage risk to the point that it's eliminated. And that's where insurance comes in. And with insurance, that's a way of preserving assets. You're able to protect your assets. And many of you are familiar with property and casualty insurance because you own automobiles, and many of you, I'm sure, own homes. And as a result of that, you have purchased automobile and homeowners insurance. Each of those types of insurance, you have a package of different coverages that come along with that. And so you have to purchase that. You have to purchase automobile insurance because it's the law in most states. And of course, it is in Georgia in terms of liability insurance. And if you're financing your car, of course, it's a requirement by lenders that you have it. But even if you're not financing, you still should have insurance on your automobile, at least liability, even if you actually have an older car where it's no longer important to have other types of insurance. Homeowners insurance, of course, is required by mortgage lenders, but even at the point you pay your home off, it's still important to have homeowners insurance so that if there is some type of a peril that you're exposed to, like a tornado, a hurricane, fire, theft, things of that nature, that you will have coverage and be able to be reimbursed for the losses that you have. So property and casualty insurance is important. Life insurance is important to some people. The primary purpose of life insurance is to is for you to provide financial stability for your loved ones in the event of your premature death. So the primary purpose is that if you think that you may, or no, you don't really have to think, because you don't always know what's going to happen in life. But if you have like a spouse, or if you have children, young children, and you're the primary breadwinner in your home, of course, life insurance would make sense, because anything could happen to you. You could leave to go to work and then be in a car accident, or anything could happen. And then you want to make sure that your family, or those who are dependent upon you, have adequate finances to be able to survive if you were no longer here. So that's what life insurance is all about. And for many of you, you probably have, you may have life insurance because of those reasons. Health insurance is another type of common insurance that everybody needs. And of course, health insurance can protect you. It can't protect you against getting sick. However, it can actually provide the resources that you need to be able to get the health care that you want in the event that you do become sick. And I know most health insurance plans now do put an emphasis on preventive health care. And most of the time, there are no co-payments or no co-insurance or no deductible that applies when you go to healthcare providers for preventive health care, like physical examinations. And many health insurance companies now are also even paying for things like different types of programs that you can be a part of if you are actually high risk. So health insurance is something that many of you are familiar with. You probably have through your employer, and if not, you probably have it outside of work in some form or fashion. Two other types of insurance that most people don't think about as much are disability insurance and also long-term care insurance. And so these are the two types of insurance that I'm going to provide more information about in my presentation today. And and the purpose of it, talking about insurance in general, is basically to protect your assets, because if you were to have a loss and you don't actually have insurance, you can use up all the financial resources that you have trying to actually cover those losses. So it's important to have the insurance that you actually need. And because most people are more familiar with property and casualty, life insurance, and health insurance, or they're less familiar with disability insurance and long-term care insurance, I wanted to take a few minutes and spend a little bit more time talking about these two types of insurance. Okay, disability insurance, before basically talking about what it actually is, I just wanted to point out that there's much literature that talks about how the likelihood of long-term disability is actually greater than premature death. And that is especially true at younger ages, in your 30s. So your likelihood of becoming disabled is greater than it is you dying prematurely. And many people don't think about that. They think about life insurance, but they don't think about the fact that they could become disabled. Also, it's estimated that 1 out of 3 persons will have a disability that lasts 3 months or more. And it's estimated that 1 out of 10 persons will have a permanent disability before they turn age 65. So disability insurance is also important to have in the event that you do become disabled, because some people will say, well, I'm covered through workers' compensation on my job, but workers' compensation is not overall disability insurance. Workers' compensation covers you if you have a work-related disability or illness. And if it's not work-related, then of course, if you have a disability and don't have disability insurance, then you could have to use up many of your resources, financial resources, to be able to survive during the period of disability. Disability insurance actually replaces 60 to 80% of your income if you are unable to work due to an illness or injury. The benefit amount, of course, then is going to depend on your income. For example, if you were making $1,000 a week and it paid 60%, then of course that's $600. If it paid 80%, that's $800. So it's based on the income that you have, but it replaces typically anywhere from 60 to 80%. I think the policy that we have at the University of Georgia replaces 60% of income. There is usually also a maximum benefit amount. So what that means is this: if that 60 to 80% that you're being paid is actually higher than that maximum amount, then you are capped at that maximum amount. And there are many, really higher income people that the 60% or 80%, if it goes that high, could actually pay them more than whatever that maximum benefit is. And if that is the case, then they are limited to whatever the maximum benefit is on the policy. There are some important definitions that people should actually be aware of when it comes to disability income insurance, and some of these I have listed here. One definition is what's called own occupation. Own occupation means that if you have a policy that covers own occupation, that basically means that the policy pays if you are unable to perform the occupation for which you are educated and trained to do. Any occupation is a policy that actually covers, that actually only covers you if you are unable to perform any occupation. So you can see the differences in definitions. So one policy basically will pay if you're unable to perform the job for which you are educated and trained. The other one only pays if you are unable to perform many occupations. I can remember I had a hairdresser a while back, and she was having some problems, and she actually had a disability policy, and she basically was trying to receive benefits, but there were two jobs that they said that she could actually do because it was based on any occupation. You also have what's called a hybrid policy. A hybrid policy is similar to what we have at the University of Georgia. That means it's both own occupation and any occupation. And what that means is that you can have a policy that will pay you for so many years if you are unable to perform your own occupation, but then after that period of time expires, then it will only continue to pay if you are unable to perform any occupation. So a hybrid policy has a combination of both of those definitions and will pay for a period of time based on own, and then it switches over to any occupation. Then you also have policies that will pay you if you are partially disabled. And that means if we'll pay you a benefit, continue to pay you a benefit if you are able to come back to work part-time or able to come back to work and only do part of your duties. So those are some important definitions to keep in mind when you are looking at disability income insurance, especially if you're looking for it outside of a group policy. Now, if it's part of a group policy, you have to, and you're purchasing the group policy, you have to purchase what is being offered to you through your employer. However, if you're purchasing it outside of your employer, then you can actually look at these different things and make comparisons about what's important to you. Some additional policy definitions are the benefit period. That is the period of time that the policy will pay you once you become disabled. There is also the elimination or waiting period, as it is referred to. That is the period of time between when you become disabled and when the policy will actually begin to pay. Because the policy doesn't pay from day one, you have a waiting period in terms of how long you have to wait before you can start to receive disability benefits once you become disabled. So policies also have pre-existing conditions, which means that if you are disabled as a result of a pre-existing condition that you had when you purchased the policy, then you may have to wait a certain period of time before that disability can actually be covered. And then most policies will have exclusions, and they will also have limitations as well. You know, one of the things that I noticed on our policies in terms of limitations, there are many exclusions because self-inflicted injuries that cause disability are excluded. There are many things excluded, but an example of a limitation might be on our policy. One of the things that I noticed is if you have a disability that is a result of a neurological condition that leads to like pain or whatever, then the policy will only pay you, I think it's 2 years for that. So that's just one example. So be sure to make and look at all of, you know, what is included on the policy if you're actually shopping for it. There's basically two types of disability insurance. You have short-term disability and long-term disability. Short-term disability, usually they pay benefits anywhere from 2 to 6 months. The waiting period can be a couple of weeks to 1 or 2 months. It just depends on how long the benefit period is. The University of Georgia's short-term disability policy has a waiting period, I think, of like 14 days, which is actually 2 weeks. And then a lot of people will purchase the short-term disability to cover their waiting period on their long-term disability policy. And that is one thing that you can do. But another thing that you can do is also don't waste your sick days. And if you become disabled, you can have sick days that you can also use during any waiting period on a long-term disability policy as well. Long-term disability, the benefit period can last anywhere from 2 to 5 years, or it can last until retirement and or death. A disability insurance policy is not going to pay you once you reach retirement age, because at that point it is time for you to retire. And even if you were working, you would have been probably retiring at retirement age. So they usually will pay anywhere from a few years up until retirement or death. And then with the long-term disability policy, you will typically have waiting periods anywhere from 3 to 6 months. And as I mentioned, that is typically why some people buy short-term disability, to cover the waiting period on the long-term disability if they have it. Now, just a little bit about long-term care, because I know time is going by really quickly. Long-term care includes a variety of different services. Those services can be medical or non-medical, and they're for people who may have chronic illnesses, injuries, disability, or experiences other limitations due to aging, such as any form of dementia. Long-term care can actually helps meet health and or personal needs. There are some myths about long-term care that people actually have. Some people say, I'm too young to need it. You could need long-term care even when you're not an aging individual. Anyone could be put in that type of a situation. Some people say that, oh, my family's going to take care of me. And most of the time I tell them, good luck with that. And then some people depend on Medicare and Medicaid to cover their long-term care bills, but Medicare does not cover long-term care. Medicare is a health insurance. There are some coverages that based on limited coverages that Medicaid will cover, but not everybody actually qualifies for Medicaid. And some people say, well, I have health insurance, so I don't have to worry. Health insurance does not cover long-term care. A regular health insurance policy does not cover long-term care. And some people say, well, I'm going to save to cover my long-term health insurance needs. Of course, we all hope that we don't have to end up paying long-term care expenses. We don't hope that we don't have to need it. But if you need long-term care, I don't know that you're going to be able to save enough to cover that on your own and be able to meet the other needs of yourself and your family during that time. Long-term care services are provided when a person cannot perform what is actually called activities of daily living, or they can be cognitively impaired. They may be able to perform activities of daily living, but they may be cognitively impaired, have some form of dementia. So that's when long-term services are actually provided, typically on a long-term care insurance policy. So what are activities of daily living? These are some of the activities of daily living, things like eating, bathing, dressing, being able to transfer yourself from your bed or to your chair, toilets, incontinence, things of that nature. And when I actually shopped around for long-term care insurance, it's been many years ago now, in my 50s, it was early 50s, many of the policies would pay if you were unable to perform 2 to 3 of these activities of daily living. What does long-term care insurance cover? Long-term care insurance can cover a variety of different things, and these are some of the things that it can cover here: skilled, intermediate, and custodial care, home care services, physical therapy, homemakers, home health aides, also assisted living, if you have to take someone to adult daycare, things of that nature, and any other types of services, long-term care insurance services that may be recommended by your physician. And one of the things that I learned when I was shopping for long-term care insurance is that I didn't know is that it also covers respite care for the actual caregiver, which I think is very important, because if you have never cared for someone who have been chronically ill, you can't even imagine the toll that it actually takes on a caregiver. Actually, my husband was diagnosed with acute myelogenous leukemia when a little while after we were married, and I provided a lot of care for him, and it can actually be physically and also emotionally draining when you're caring for someone that you love in that manner. So that is actually nice to be able to have that for caregivers as part of long-term care insurance policies. There are different types of policies. Reimbursement policy is the most common, and that's when you are reimbursed for your actual charges up to, of course, you have policy limits. It will continue to pay until you expend all of your benefits. And then there's something that's called an indemnity policy. They used to have health insurance policies that were called that as well, and they're usually just paying you set dollar amount, and it's based on what is outlined in the actual policy. It's not a very common policy. And then there is something that is called partnership policy. A partnership policy can be also a reimbursement policy as well, but the idea is that partnership policies will protect your assets if your long-term care insurance benefits are exhausted. I know that many people are concerned about having to use up all of their financial assets before they can actually qualify for Medicaid. And so Medicaid can actually help them. I get that question a lot from people about Medicaid and how it works, and will they be able to take my assets, and how can I transfer them to my children, and things of that nature. And so states could actually decide, and Georgia was one of those states a few years ago that decided that they would offer partnership policies. So if you buy a long-term care insurance policy, and even and once you use those benefits on that policy, even if you run out of those, if you use up your policy benefits, your assets are still protected, and you can still possibly qualify for Medicaid without exhausting all of your financial resources, and still be able to pass those resources down to your children. So looking into a partnership policy is probably one of the best options if you are considering long-term care insurance. Now we're going to change gears a little bit, and I just wanted to pull these people up because, and usually if I am in the room with individuals, I will ask them, what do these people have in common? Of course, since we're not having, you know, I'm not in the room with individuals, I can't really ask that question, but you can see the question and you can kind of get, somebody just type in there they're dead. Yeah, that is actually true. All of these people are dead, at least the last time that I checked, that they are actually dead. And so basically you can tell that from the very first one, Aretha Franklin. But when I actually looked into all of these people, because I was trying to find different wheels and different things for celebrities, and I found this information, and either these people did not have a will when they died intestate, or they had wills that were very questionable, or there were some kind of issue with their will. Or they didn't think they had a will, and then later on, a few years later, they found a handwritten one. So yes, all of these people are dead, but many of them, there was an issue with their will. They didn't have one, or there was some issue with the will that they had. And so basically, I'm going to be changing gears and talk about a little bit about estate planning. And the first thing I wanted to discuss is, why do people fail to create estate planning documents? And these are some of the common things that I've heard from people over the years. I've been doing this for a long time, and I get all kinds of comments from people. Some people say, I haven't had the time, there's procrastination. And some people say, well, I don't like to think about that, bad health or death. I understand that too. None of us do. But the bottom line is this: just because you don't think about it doesn't mean it's not going to happen. And then some people say, well, estate planning is only needed by old people and people who have a lot of money. I say elderly and wealthy. Some people say a simple will lasts a lifetime. Not true. Some people say, well, the state has laws to protect my estate. Yes, that is correct. The state does have what they call intestacy laws, or some people refer to them as the laws of descent and distribution. Yes, they do have those laws, but those laws are not necessarily what you would want to happen with your estate. So planning is still important. Some people say, well, I have joint ownership. I own my house with my spouse, and so I don't have to worry about that. Yes, but what about everything else that you own? So joint ownership is not a substitute for estate planning. It's just a part of estate planning. And then some people say, well, estate planning, it costs too much money. But in my experience, my education and experience has taught me that it's always cheaper to plan. It's always going to cost you more when you don't plan. So, dying without a will, what does that mean? That means you have basically died intestate. That means you have died without a valid will, or you have died without a will that does not provide instructions for distributing all of your property. Now, that is harder to do nowadays because most wills will have what's called a residual clause in them that will prevent that from happening. However, it is a slight possibility that it could happen. If you have a valid will when you die, then that means you have died testate. And then I have this question here: when will your will be considered invalid? And basically, every state, some states have laws that will invalidate a will. And up until I think maybe like a couple of years ago, Georgia also had criteria or situations that would invalidate a will, but that has since been changed. Those things in the past that would invalidate a will were getting married, birthing a child, and also the adoption of a child. But a few years ago, Georgia changed that for whatever reason. I don't know the reason why. So now those things no longer invalidate a will. I think there are some new things written into the law where the spouse still receives intestate portion of the person's estate or something to that degree, but the law was changed. But I did want to mention that there used to be things, and in other states, if you ever move to another state, that state will probably have things that can happen that will invalidate a will. Okay, what are Georgia's intestacy laws? Georgia's intestacy laws basically depend on your family, the composition of your family. If you are married and you have never had children and don't have any grandchildren, then that means if you died without a valid will, Georgia, everything would go to your spouse. If you are married and you have children, how things are divided if you died without a will depends on the number of children you have. If you have one child, the spouse gets 50%, the child gets 50%. If you have two children, the spouse gets a third, and each of the children will receive a third. If you have more than two children, then the two children have to split the actual 2/3 because the spouse in Georgia never receives less than 1/3 of the estate. That is actually a lot better than it was when my husband died back in the early 90s. My husband died in the early 90s, and it used to be 1/4 of an estate, but now it's 1/3. So therefore, if you have more than two children, then the spouse never gets less than a third, and the children will have to split the remaining 2/3. Now, if you have a child that is deceased and that child actually had children, their portion will pass down to their children. In Georgia, the law is based on what they call per stirpes, and so it would pass down to their children. Now, let's assume that you have never been married, you've never had any children or grandchildren, then everything at that point would go to your mom and your dad. If your mom and dad is deceased, then everything at that point would go to your brothers and your sisters. If you had a brother and sister that is deceased, then that brother or sister's children would receive that share. If you had no brothers and sisters and no nieces and nephews at all, then it will go to your grandparents. And if your grandparents are deceased, then it will go down to your aunts and your uncles. So that's how Georgia's law is set up at this point in time if you die without a valid will. So therefore, I mean, hopefully that will not happen. And as I said, every state has intestacy laws, but those laws may not distribute things in the manner in which you would want those things actually distributed. Okay, now I want to talk about some documents and strategies that you use to transfer assets. Wills are one, property titling is another way, designating beneficiaries is another way to transfer property or assets. Trust and also giving gifts is another way of, or two other ways of transferring assets. Okay, what is a will? A will is a legal document that allows you the opportunity to control how your property or your assets are going to be distributed at your death. And basically, I just have three things here that you do in a will, but of course there are other things. Distribute your property to your heirs, appoint an executor. You can also appoint a guardian for your children. And then if you have a valid will, then that prevents your assets or your property from being distributed according to the state's laws, which are the intestacy laws. Okay, what are the legal requirements of a will in the state of Georgia? The legal requirements in Georgia are you must be at least 14 years old. That age is more higher in some states. You must be of sufficient mind and memory that you are creating a document to distribute your property after you die. You know, when I was in school, they used to tell us you have to know the object of your bounty, which means you have to know what you own and you have to know who your heirs are. Now, it doesn't mean you have to give it to your heirs. It means you have to be of sound mind to know who these people are. Who are your relatives? Who are your children? Who's your spouse? And all of those things. The will must be in writing, and the will must be signed by you and witnessed by at least two people who are not going to receive any property through your will. Okay, another way of transferring assets is actually through property titling. And that's something that a lot of people don't think about. Transfers, there are different ways that you can transfer property. If you own property that is considered fee simple, which means that only you own that property, meaning that I own my house solely in my name, or tenants in common, which is a type of joint ownership, but I own my portion and you own your portion and I can do what I want with my portion, and also any personal property that you have, those things you have to include in your will, or if you don't have a will, then that means those things are distributed according to Georgia's intestacy laws if you are in the state of Georgia, or whatever state you're in, whatever their intestacy laws are. However, if you own things through joint tenancy with right of survivorship in the state of Georgia, that does not go in your will. That will directly go to the joint person that you own that property with. For example, if you own that with your spouse, when you die, by title, it's transferred by title and it will go directly to your spouse. If you own it with your child or your children, it will go directly to your child or your children. So you can transfer joint tenancy with right of survivorship if you own your home that way. If you own anything that way, it doesn't go in your will. It's actually passed directly by title. And there's another way that things can transfer by title, and it's called tenancy by the entirety. However, Georgia does not actually allow that type of ownership in the state. So, and that can only be done between a husband and wife, but it is a type of joint ownership that also transfer by title. And it is, people do own that in different states, own it that way in different states, in case you do decide to move to another state and you hear about that type of ownership as well. The difference between joint tenancy with right of survivorship and tenancy by the entirety is that joint tenancy with right of survivorship can be owned with anyone, your spouse, your children, or anybody you choose. Now, most people choose to own it with their spouse, but it doesn't have to be. Tenancy by the entirety, which is not in the state of Georgia, can only be done with your spouse. Okay, you can also transfer assets by designating beneficiaries. For example, on your life insurance contract, your retirement accounts, you can actually name a beneficiary. And when you name those beneficiaries, then those assets will transfer outside of your will. You name who you want to have it, and it goes directly to those individuals. You can do the same thing with your bank accounts, with what's called payable on death, which is a type of beneficiary type designation, and then also transfer on death with your investment accounts. So that is a way to also transfer. You don't put this in a will, you indicate the person or persons that you want to have it, and then it goes directly to them outside of your will. Okay, also during life or during death, you can also create what's called trust. And a trust allows you to transfer the title of your assets to another party to benefit others that you want to benefit. For example, I always think of trust not literally, but figuratively, like you have a basket in a big basket in a room, and you just start throwing things in the basket. You put life insurance in the basket. You put financial assets in the basket. You can put cars in the basket, houses in the basket. And then you create this basket of everything that you own. And then you actually allow someone to manage that basket of assets for you for some other people. So basically, the person who create the trust is called the grantor, or sometimes people just say creator. The person who is going to manage that trust would be called the trustee, and the person who benefits, or the persons who benefit from the trust assets, would be those people who are considered the beneficiaries. Okay, and during lifetime, you can also distribute assets by just giving them away. You can actually give gifts and reduce the value of your estate. For example, gifts are taxable, but there are exclusions and exceptions that prevent them from being taxed. And so you can actually give away up to $15,000 per person. That is the amount currently for this year. You can give away $15,000 per person to as many people as you want without any gift tax consequences, if you're trying to reduce the value of your estate before you pass away. And then if you are married, you can actually do $30,000, because both you and your spouse can give 15, and that's what they call gift splitting. And then if you go over that 15,000 or 30,000, if you are married, then you don't pay any taxes, because it goes toward your lifetime exclusion amount, which is at currently this year, I think it's 11.7 million per person. Few other things that I wanted to cover, because I know I only have about 5 minutes left, are documents and strategies that you use to handle other estate planning issues that are very important. And those are power of attorney, the living will, and the Georgia Advance Directive for Healthcare. Power of attorney is a legal document that allows another person, that person is referred to as your agent, to act on behalf of another person who is you, the principal. And the power of attorney, in my opinion, should always be durable. That means that the power of attorney will continue to remain in force if you become incapacitated. So having a power of attorney that is durable is so important. There's no power of attorney that will continue after you die. Now, in the Georgia Advance Directive for Healthcare, there are some things that you can indicate that you want in terms of whether or not you want an autopsy for your body to have an autopsy and things of that nature. But once you die, you're no longer. I heard some people say, well, if so and so die, I'm in charge because I'm their power of attorney. But a power of attorney is different than an executor of a will. And so you may be a person's agent on their power of attorney, but they may not have indicated they wanted you as their executor once they die, to manage their assets. So power of attorney is while you are living. There are basically two different types of power of attorney. One is called a power of attorney for finances, and that means you can appoint a person to manage your property and your finances. You can have a very narrow power. For example, you can just have somebody paying your monthly bills, or you can have somebody, it can be very broad, where you can have them being able to purchase property for you, purchase insurance in your name, different kinds of things. You decide how specific or how broad that you want the power to be. It's entirely up to you. And then the durable power of attorney for healthcare, and that appoints a person to make healthcare decisions on your behalf. And then there is another document that is called a living will. And some people do refer to this as an advanced medical directive or a healthcare proxy. And it is a legal document that expresses your desires regarding life-sustaining equipment if you can't make that decision. So the major difference between a living will and a power of attorney is a living will is just indicating what your preferences are, whereas a power of attorney is appointing someone to make those decisions for you. And those documents are so important because you could end up in a health situation where all of your financial resources could be used, and that may not be trying to keep you alive, and that may not be what you actually prefer. So you need to make sure that people are aware of what your preferences are, so that and if it is your preference that all your resources be used up to keep you alive, then that's your preference, but it just needs to be made known. And Georgia has what is called, a few years ago, I think it started back in 2007, Georgia came up with a standard form, and it has since, of course, been updated since that period of time. But they have come up with this standard form that combines a power of attorney for healthcare, a living will, and a guardianship in one form. And basically, that form is called the Georgia Advanced Directive for Healthcare. And it makes it so much easier for you to put together these documents. You can do part of it. If you just want to do the power of attorney part, you can. If you just want to do the living will part, you can. If you just want to do the guardianship part, you can. It's entirely up to you, or you can actually do both. I mean, all of those if you choose to do so. And it's just a good way of being able to do it. You can actually do it yourself. You can go to an attorney, but you can actually fill it out yourself. And of course, you do have to actually have some witnesses for this particular form. And I think I finished right on time.